Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors legal hotline lawyer. Today's video is another in our continuing series entitled Real Estate Fundamentals You Should Know. This is a question that comes up quite a bit, believe it or not. We have a married couple, but only one member of the marriage is going to be on title to the property. Why? It doesn't really matter why. Maybe it's because of financing, maybe it's because somebody's out of town, maybe it's because somebody's getting a divorce and the divorce isn't yet final, but the person that the buyer wants to go ahead and buy even before the divorce is final. Any number of reasons, we don't care what it is. The question is, does that fact have an impact on the transaction? And the answer is absolutely yes. The impact is that the title company, assuming the buyer has to get financing, the title company will not insure title for the buyer's lender unless that spouse whose name will not appear on title signs a quitclaim deed, releasing their interest in the property. Why does the spouse have any interest in the property? Because Washington is a community property state. So by mere virtue of the fact that one spouse takes title to real estate, the other spouse has at least a presumptive interest in the property as well. And the title insurance company will not insure title to that property without somehow or another that the non-title taking spouse disclaiming all ownership interest in the property. The way we do that is through a quitclaim deed. Listing brokers, here's what you need to do in this situation. I've seen all kinds of crazy ways. Listing brokers are smart enough to know they've got a problem, but I'm seeing lots and lots of crazy ways for listing brokers to try and solve the problem. Here's how you want to solve this problem. You include an addendum as a counteroffer from seller. And the addendum makes seller's obligation to perform the terms of the purchase and sale agreement contingent upon the non-title taking spouse delivering a fully executed and notarized quitclaim deed to seller within X number of days of mutual acceptance. It should not take long for a buyer's spouse to sign the quitclaim deed if they're willing to sign a quitclaim deed. Now, it might take a little bit of time because they're going to have to go find somebody to prepare the quitclaim deed. Real estate brokers aren't licensed to prepare the quitclaim deed, and most escrow companies won't prepare the quitclaim deed. So they might have to go to a lawyer to get the quitclaim deed prepared that the non-buying spouse would then have to sign, have notarized, and provide to the seller. Seller would then take that quitclaim deed, deliver it to title. Title would say, yes, this is sufficient to have the non-buying spouse interest in the real property released, and we will insure title on this basis. If you don't do that at the time of mutual acceptance, then what happens instead is seller has their property tied up all the way to closing. You get to the closing table only to find out that that non-buying spouse says, I'm not signing that quitclaim deed for whatever reason. And sometimes that can even happen if the two buyers are friendly with one another. Maybe the buyers just had a change of heart, and a good way for the buyer to get out of this transaction to be unable to get their financing, if they still have a financing contingency, is for that non-party, that spouse who's not a party to the purchase and sale agreement, to refuse to take action that's necessary in order for the buyer to be able to perform the terms of the transaction. So in other words, buyer hasn't breached the agreement, buyer's performed in good faith, there's a third party out there who's not taking some action that would enable buyer to get the financing, so buyer gets out of the transaction based on their financing. Listing brokers, you prevent that outcome by requiring delivery of the fully executed quitclaim deed close to the date of mutual acceptance. The question that often comes up is, how can a non-buying spouse, how can anybody sign a quitclaim deed on property that they don't own yet? And the answer is, that's the whole purpose of a quitclaim deed. A quitclaim deed says that if I have any interest in this real estate, I give it to you. I could give every person watching this video a quitclaim deed to the Eiffel Tower, and I would not owe you anything along with giving of that deed, because I have no interest in the Eiffel Tower. And so the quitclaim deed would have no meaning whatsoever, because all it says is if I have any ownership interest, I give it to you. So the non-buying spouse can sign that quitclaim deed up front, deliver it to the seller. Seller won't record it. The title company won't record it until closing, because that's the only time it would have meaning. And if the title company never uses it, never has to record it, then the fact that the non-buying spouse signed it is irrelevant. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.